We all put without prejudice at the end of our letters and communications. It's often overused by non-litigation lawyers, but the underlying reason for using these words in Scotland, England and Wales is the same. It's to encourage parties to resolve matters out of court and to prevent statements made in a genuine attempt to settle from being put to the court as evidence of an admission against the interests of the party that made them. However, the Scottish courts do take a different approach to the concept of an admission to that taken by the courts of England and Wales. The courts of England and Wales have given the words without prejudice a fairly wide meaning, in the sense that it effectively includes all matters disclosed or discussed in without prejudice communications, and the rationale for this seems to be that dissecting out identifiable admissions and withholding protection from the rest of without prejudice communications would create huge practical difficulties, as well as being contrary to the underlying objective of encouraging the parties to speak freely in trying to settle their disputes. Without prejudice correspondence in England and Wales then seems to us sacrosanct, save in the face of a compelling policy reason. In Scotland, there's a distinction between statements made in an attempt to achieve an out-of-court settlement and admissions of fact. The privilege only attaches to the former, not the latter, so admissions of fact are not privileged in Scotland, and that's really to demonstrate the different approach taken north and south of the border. The English approach appears to be more context-based and the Scottish approach more content-based. In Scotland, the words without prejudice do not themselves give protection. We have to look at the content of the communications. So if, for instance, there's a clear acknowledgement that liability is accepted, the addition of the words without prejudice will not necessarily prevent the statement being founded upon in court. If a statement of fact is not later to be used against a party, it must be clear that it is a proposition made for the sake of settlement and not an unequivocal admission of facts. Using the words without prejudice does not automatically prevent the communication from being admissible in the Scottish courts, and that's the fundamental difference between us north and south of the border. We do find here there are a variety of ways in which without prejudice is communicated. Some solicitors have elaborate wording at the end of their letters that can stretch to lengthy paragraph, but basically all that is required is for the letter or email to state that it is written without prejudice to the client's whole rights and pleas, and it may not be founded upon. And as we've discussed, in Scotland, that protects the offers made, but not the assertion of any fact.